Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 44th lecture series. Before going on to the topic, it is our regular practice to recite the preamble of the Constitution of India with a strong faith in the preamble that is our goal and that is our soul, because entire constitution, their goal are enshrined in the preamble, and it is one of the fundamental duties guaranteed under article 51A, which says that, which prescribes the fundamental duties on our part to remember our forefathers, and we have to try our best to realize their goals enshrined in the preamble. Therefore, only when we recite, it will get registered in our mind. Once it is registered in our mind, we can put it in practice. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, we have gathered here to discuss about a very important topic asked in the AOR examination. So what is the topic and which year that question has appeared? Let us find out that. (2021) question paper 2021, part 2, question number 6, and it carried 10 marks. What was the question? Article 136 of the Constitution of India expressly confers upon the Supreme Court the power to review its own judgments. Which order of the Supreme Court lays down the grounds to be taken for a review petition in a proceeding arising out of civil matters, and which grounds should be taken in a review petition filed in a criminal proceedings? So in short, what are they asking is, what is the power of the Supreme Court to review its own judgment? So for this purpose, we have to first see the constitutional provision, that is Article 137 of the Constitution of India, because Article 136 deals with special leave petition. Article 137 deals with review jurisdiction of the Supreme Court. So what does it say? The Supreme Court shall review its own judgment pronounced or order made by it. So this is the power given to the Supreme Court. Two reasons, dear friends. The principles evolving here is, firstly, the review petition, the scope of entertaining is very, very narrow. The review petition cannot be widened as that of the original proceedings. But under few grounds, under the grounds which are given in the rules, we can urge and we can ask for the review of their own judgment. Why it is not entertained, first of all? Why the scope is very narrow? Why it is not entertained? Because the principle is, there should be a finality attached to the judgment. That is the principle. Even you can see this principle in res judicata also. In res judicata, the same party, same cause of action, same subject matter, he has a right to prefer an appeal, but he cannot urge before the same court on the same matter. Why? The public policy is that there should be a finality attached to the judgment. So the same principle applies here also. The second principle, why review petition is entertained under certain circumstances. The answer is judicial fallibility. At times, even the honorable judges may go wrong in passing the judgment or the orders. So there is an element of fallibility. So therefore, to prevent miscarriage of justice, to advance substantial justice, therefore review is entertained under certain few grounds. So these are the two principles evolving from this exercise of review jurisdiction over the matters by the Supreme Court. Now, having seen what is Article 137, what are the other provisions that you will look at it? That is, Article 145 deals with rules of the court. Article 145 deals with the rules of the court, which empowers the Supreme Court to frame its own rules to deal with appellate jurisdiction, to deal with other jurisdictions, and to regulate who are the advocates practicing before the concerned court. Therefore, even advocate on record, senior advocates or advocates are regulated by the Supreme Court rules, as well as what are the subject where, for example, specially petition, a criminal appellate jurisdiction, form number 28 of the Supreme Court rules provides for it. So accordingly, what applies to the review jurisdiction? What applies to the review petition? That is given under Order 47 of the Supreme Court Rules 2013, dear friends. Let me read that for you. See, we are going step by step. First, we are looking at the provisions from the Constitution. Then under provisions, Article 145, which empowers the Supreme Court to frame rules. By virtue of that, Supreme Court rules have been framed. Now, Order 47 review, which deals with nearly 5 rules, dear friends. So, Order 47 has got 5 rules. What are they? Rule number 1. The court may review its judgment or order. See, every word is very, very important, dear friends. The court may review its judgment or order, but no application for review will be entertained in a civil proceeding. How it starts in a negative note. No application for review will be entertained in a civil proceeding, except, that means generally review petition is not entertained, but except on certain grounds. What are those grounds? The grounds mentioned in Order 47, Rule 1 of the Civil Procedure Code. See, Order 47, Rule 1 deals with of CPC, deals with the review. Same Order 47 deals with the review in a Supreme Court rules also. So easy to remember. So they are splitting up in two ways. One is civil proceedings, civil cases. Another one is criminal cases. So for civil cases, what are the grounds that you will urge? You will urge the grounds whatever stated in the CPC, more particularly Order 47 CPC. Now let us move on to the criminal proceedings. And in a criminal proceeding, except on the ground of an error apparent on the face of the record. So you cannot urge the grounds what is available in CPC, you cannot urge for the criminal cases also. For criminal cases, it is only an error apparent on the face of the record. So you cannot fish out what was missing. You cannot search what was the error committed. It should be apparent on the face of the record. So the application for review shall be accompanied. This is very important, dear friends. At times they will ask who can issue the certificate, and certificate, what will be the content of the certificate. The application for review shall be accompanied by a certificate of the advocate on record, certifying that it is the first application for review. So a certificate will be issued by an advocate on record. So what will be the content of that certificate? The first is that this is a first review petition, certifying that it is a first application for review. Number 2, it is based on the grounds admissible under the rules. So that should be the content of the certificate issued by the advocate on record. So 2 contents, dear friends. Firstly, an advocate on record should certify that this is the first review petition. And second is, whatever the grounds that we have urged in the review petition, it is permissible under the rules. So these are the 2 elements to be present in the certificate issued by the advocate on record. Now coming to the rule 2 of order 47, an application for review shall be by a petition. So you will hand it over by way of a petition. You will file it by way of a petition, and shall be filed. What is the time limit? Time limit is 30 days. 30 days from when? From where? From the date of the judgment or order pronounced by the Supreme Court. For example, SLP, it is 90 days. For review, it is 30 days. So, and shall be filed within 30 days from the date of the judgment or order sought to be reviewed. It shall set out clearly the grounds for review. So it should be very precise and clear. What is the, why do you seek review of the matter, of the order or the judgment passed? Now rule number 3, dear friends. Unless otherwise ordered by the court, unless otherwise ordered by the court, an application for review shall be disposed of circulation without any oral arguments. But the petitioner may supplement his petition by additional written arguments. Generally, when we file special leave petition, it comes in the open court, where we have an opportunity to advance our arguments before the court. But in review petition, how the matters are listed before the honorable judges? It is through circulation. They are called chamber judge. See, our friends might get confused with reference to the nomenclature chamber judge. It is a listed, matter is listed by circulation inside their chamber, and no advocate shall be permitted to appear before them in the chamber when a matter, review matter was given for circulation. So you will not get an opportunity, but generally what we do is, while filing a review petition, we will file an application for oral hearing in the court. And now the rule permits that we can, whatever you want to make an argument, make it as a written argument and submit it along with your review petition. Another chamber judge is where the defect matters are listed. Some application, it is given in our rules itself, dear friends. What is the business, or what are all the powers of the chamber judge, and what sort of matters that they can hear. This time they might ask in the AOR examination, what is the power and functions of the registrar court, power and functions of the single judge and the chamber judge. These are all most repeated questions. So you must concentrate on this. The court may either dismiss the petition or direct notice to the opposite party. So what will happen when a review petition is listed before the court, before the chamber, inside the chamber? They might dismiss it, or otherwise there is yet another possibility to issue notice to the opposite party, that is the respondents. The court may either dismiss the petition or direct notice to the opposite party. An application for review shall, as far as practicable, be circulated to the same judge or bench of judges that delivered the judgment or order sought to be reviewed. So when an order passed by the same judge in the SLP, when you file a review petition, review means kindly review your order, kindly appreciate your order, there is an error apparent on the face of the record. So that order which we are seeking to review, that has to be placed before the same judge who had passed the original order. That is important. In case if they get retired, then it is up to the prerogative of the Chief Justice of India to allocate the matter. So otherwise, generally, the matter is listed before the same bench who had already decided the previous order, the original order. Rule number 4. Where on an application for review, the court reverses or modifies its former decision in the case on the ground of mistake of law or fact, the court may, if it thinks fit in the interest of justice to do so, direct the refund to the petitioner of the court fee paid on the application in whole or in part as it may think fit. So once in a review petition, if it is dismissed, we cannot ask for the court fee. But if it is modified, if there is some material changes made in the review in favor of the petitioner, they can ask for a return of court fees. So they can ask to direct for the refund to the petitioner of the court fee paid either fully or in part. Now moving on to Rule 5 of Order 47. Where an application for review of any judgment or order, I repeat dear friends, where an application for review of any judgment and order has been made and disposed of, no further application for review shall be entertained in the same manner. So second review petition is not maintainable. And you cannot suppress the fact of dismissal of review and then you cannot file once again the second review petition. So the rule itself prohibits that you cannot file a second review petition. Again, the principle of res judicata. There should be a finality. So these are the 5 rules under Order 47, dear friends.
Article 235.
Dear friends, now we are moving on to Order 47, Supreme Court rules is over. Now let us move on to the relevant case law with respect to this. 2013, Volume 8 SEC, page number 320 after. 2013, Volume 8 Supreme Court cases, page number 320. It is a very important judgment, dear friends. Kamlesh Verma versus Mayawati and others. I repeat, Kamlesh Verma versus Mayawati and others. So what is this case about, dear friends? They have summarized the principles of review petition in this case. They have summarized the principles of review petition in this case. So the facts goes like this, dear friends. Let us understand the facts. In a writ petition, there was an IA preferred interlocutory application. In the interlocutory application, the IA, for what purpose? They wanted to investigate into the scam committed with respect to the project Taj corridor matter. So in that, IA was allowed and they have directed the CBI to investigate the matter and submit a report. So they found there were irregularities, so which culminated into the registration of FIR against the accused. So FIR was registered. Thereafter, the police officials, they registered exclusively FIR against former Chief Minister Mayawati. That order, second FIR, was challenged by way of a writ petition before the Supreme Court. That was allowed in her favor. Against that, review was filed, saying that writ petition, what was allowed is incorrect. There is an error apparent on the face of the record. So therefore, in this case, the Honorable Supreme Court has dealt in a very detailed manner, and they have summarized the principles when review will be maintainable, when review will not be maintainable. So this is very important judgment with respect to the principles of review is concerned, dear friends. Let me take you to the relevant portion with respect to the review. See, dear friends, you will find in criminal proceedings it is error apparent on the face of the record. But in civil cases, what are the grounds is you try to file a case, and whenever you are filing a case, you are supposed to bring all the records before the court. Once it was dismissed, what happens next? When matter was dismissed, we need to, when you are filing a review, you have to make out a ground. What sort of ground that you will make? My lords, there are certain material facts and documents which were not in my possession at that point of time of filing. Now I have discovered those documents which was not within my knowledge at that point of time. Therefore, these documents has to be admitted, and based on that, review is maintainable. So discovery of new documents, that is one ground. The second ground is, dear friends, please look at CPC order 47. Before moving on to the judgment, let me go through that. See, by a decision from the discovery of new and important matter or evidence which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time when the degree was passed or order made, or on account of some mistake or error apparent on the face of the record. See, error apparent on the face of the record, the same ground you will find it in criminal proceedings also. The same ground is available in civil proceedings also. Apart from that, this discovery of new documents, that is also there. Mistake of fact, mistake of law, that is also available. And look at the wordings used, or for any other sufficient reason. This is where the discretionary power vested with the court. Because unforeseen circumstances, in its legislative wisdom, they cannot anticipate all the situation. Therefore, they have brought out new discovery of documents or error apparent on the face of the record or any other sufficient reason which satisfies the conscience of the court. You can bring it within the scope of review. So therefore, it is wide. Civil proceedings review, scope of review is wider than the review in the criminal proceedings. Now, after reading this, dear friends, now let us see the summary of the principles evolved in this Mayawati's case. That is para 20, dear friends. Summary of the principles. In view of the above, the following grounds of review are maintainable as stipulated by the statute. 20.1. When the review will be maintainable? Discovery of new and important matter or evidence which after the exercise of due diligence was not within knowledge of the petitioner or could not be produced by him. That is first ground. Second is mistake or error apparent on the face of the record. Number 3, any other sufficient reason. So these are the principles in which review is maintainable. The words any other sufficient reason has been interpreted to mean a reason sufficient on grounds at least analogous to those specified in the rule. Now, when the review will not be maintainable, this is second category, when the review will not be maintainable. A repetition of old and overruled argument is not enough to reopen concluded adjudications. That is number one. When already matter was argued on the same argument, on the same issue, you cannot advance again and again in a review matter, or if you file it also, you must bring out certain things which was not asked before the courts below. Number two, minor mistakes of inconsequential import. There may be minor mistakes here and there, but whether does it affect the substantial justice? Does it cause serious prejudice to the party? Or does it cause gross miscarriage of justice? So, when such being the position, review can be entertained. But when there are few mistakes here and there, if it is of no consequence, does not cause any serious prejudice to the party, you need not file a review. Review is not maintainable. Review proceedings cannot be equated with the original hearing of the case. Original hearing means, for example, you can take the example of special leave petition. When we file it, we get an opportunity to argue before the court. But the same privilege we cannot expect in the review. Scope is limited. Review is not maintainable unless the material error, dear friends, it is not error, it is material error, manifest on the face of the order, undermines its soundness or results in miscarriage of justice. See how beautifully they have said. First is there should be a material error, and error on the face of the record, and it must result in miscarriage of justice. There must be an action, and because of that order, somebody is affected very badly. So therefore, review is maintainable. If it is not a material error, or if it does not result in miscarriage of justice, then review is not maintainable. A review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected, but lies only for patent error. So you cannot just file a review in form of an appeal. For example, generally, at times, they file an application for clarification. Instead of preferring a review petition, we advocates prefer IA for clarification. Why? The reason is, in review we don't get an opportunity to address the court, but in IA the matter is listed before the court. So very recently the matter came up before Honorable Justice B.V. Nagaratnaji. This IA business has to be stopped. That is what ladyship has commented, observed, that what sort of clarification. It is in the guise of appeal only you are asking. So this sort of IA should be stopped. MA, miscellaneous applications.
Can you repeat this point?
Yes. See, generally when a SLP is dismissed, what is the next remedy is review petition. When we file a review petition, the scope is very limited and it will not be heard by the court. It will be circulated among the judges in the chamber itself, and when they do not find error apparent on the face of the record, it is dismissed then and there. So there is no scope for addressing the court through our arguments. So scope is very limited and advocate's role is also very limited. To prevent that, at times we file MA, miscellaneous application, seeking review of the order, SLP order. Why do we not file review and why do we file clarification is, clarification will come up before the honorable court. At times when there is a defect, pointed out by the registrar, learned registrar. No, this is in the guise of review, you are asking a clarification. Once it is dismissed by the registrar, then that appeal can be preferred before the open court. And in the open court, matter will come, we can address in the open court and we get an opportunity. Therefore, and generally the honorable court will not interfere or will not entertain clarification. They will simply dismiss it on the ground. In the guise of review, you are asking this, you prefer review petition, we don't entertain the clarification. Clarification for what? When there is some amount is entered, for example 4 lakhs, but instead of 4 lakhs, 10 is added, 40 lakhs. So there can be a clarification only on minor discrepancies, but not like this. So there are catenary of judgments which says that don't do that. Hope understood, sir. This point is understood. So the mere possibility of 2 views on the subject cannot be a ground for review. So we generally, when we are engaged by the accused, our mind thinks in a different way how to take him out from the jail, and how to bring him relief. That is one thing. When we are engaged by a de facto complainant, a victim, our mind thinks in a different route, and we will try to see that how to put him in jail, how the accused can go to the jail. So when there are 2 possible views, it doesn't mean that you can file a review. When a Supreme Court has passed one view and there is a possibility for yet another view which goes in our favor, but merely because there is a possibility of a second view, that is not a ground for review. So the mere possibility of 2 views on the subject matter cannot be a ground for review. The error apparent on the face of the record should not be an error which has to be fished out and searched. You cannot search it and you cannot find where are the errors, how do I bring out the grounds. That should not be the case. Your case is that it should be apparent on the face of the record. See how beautifully they have said, the error apparent on the face of the record should not be an error which has to be fished out and searched. The appreciation of evidence on record is fully within the domain of the appellate court. It cannot be permitted to be advanced in the review petition. Review is not maintainable when the same relief sought at the time of arguing the main matter had been negatived. Review is not maintainable when the same relief sought at the time of arguing the main matter had been negatived. So keeping in the above principles, here review against the order was dismissed, dear friends. So therefore second FIR which was quashed, that remained, the original order remained, and the Honorable Supreme Court held there is no scope for review. So therefore, dear friends, now today what we have discussed is about the overview of the review jurisdiction. To understand the review jurisdiction, we have seen Article 137, the Supreme Court shall review its own judgment, pronounced or order made by it. In reference to that, we have seen Order 47 of Supreme Court rules. Supreme Court rule says in a civil proceeding, whatever the grounds urged in Order 47 Rule 1 of CPC applies here also. For criminal proceedings, it is error apparent on the face of the record. And then we have seen the certificate, what sort of certificate should be issued or filed by the advocate on record. 2 elements should be present. Firstly, that it should be the first review petition, and whatever the grounds urged in the review petition is permissible under the rules. And thereafter, we have discussed about this principles, summary of the principles, when review is maintainable, when review is not maintainable. And this is sufficient for 10 marks, to get good 10 marks, dear friends. So with this, I conclude our lecture number 44.